Good evening, everybody, and thank you so much for joining Simanye Clinic tonight. Our topic that will be discussed is based on medical negligence. We have with us today a guest speaker who is Advocate Chamisa. And Advocate actually he did his studies at UWC, completed his BA. Following that, he did his LLB at UCT, and his LLM in the area of medical negligence. So he is a specialist in this particular field. Advocate Chamisa is the director at DEC Legal, and he's also the director at Legal Services. So thank you so much, Advocate, for taking time out this evening to be with us. We are aware that your camera is not working, but this will be a discussion type conversation. So please feel free to take over from here. Thank you so much, Counsel.
Okay, thank you for the time. I'm going to just discuss medical negligence in the context of public hospitals, because by and large, it is often the case that people tend to approach public hospitals for medical services for various reasons. Medical negligence, I think in South Africa, it has been on an increase. I think the research that I conducted sometime, I think 2013, it was preceding that year. The statistics were showing a trend that was going up. But before I indulge into the nitty-gritty of medical negligence, I just want to give maybe the context or definition of what is medical negligence, so that at least when I indulge into the meat of it, at least there's a context to what it is all about. Medical negligence is derived from, I think, a law of delict, whereby there is a need to evaluate or appraise the conduct of medical practitioners or medical professionals. So medical negligence is contextualized in the sense that we are dealing only in the field of medicine. And mostly they call it a law of medicine or medical law, but that's the context that we'll be looking at it. So here in this context, we are dealing with negligent act or omission by a medical practitioner or by medical professionals that results in personal injury or damage. So in any context of negligence, we are dealing with a standard that is used often. The standard is that of a reasonable doctor or a reasonable medical practitioner. If I may try to put it in a factual situation, we're saying, would the conduct of this reasonable doctor be regarded as an acceptable conduct within the society or in South Africa? So we are comparing the conduct of one medical practitioner with the expected standard within the society. So if the conduct that results in one acting, or the conduct that is that one not acting with skill and care, then the end result may result in a wrongful conduct. It may result in a fault. It may result in causation and also personal injury or damage. So given this context, we have got elements that ought to be there for us to say there is damage. For instance, if one is going to take the case or one is aggrieved and wants to take the case further, they need to look at the conduct. Can it be qualified as wrongful? Can it be regarded as fault? And because it's linked to fault, we also look at causation, which is but for the conduct of the doctor, such could not have happened. Now, given this context of a reasonable person standard, so we can now move to at least maybe discuss in South Africa, what are these factors that one can allude to that they've been causing an increase in medical negligence? So we are looking at public hospitals. That's the context that we're looking at, because there are more public hospitals in South Africa in comparison with other competitive private hospitals. And also because of the reality that we have got more the general populace or most of the public people would rather go to public hospital because of the cost factors involved with private hospitals. In public hospitals, South Africa is one of the developing countries, and it tends to come across also challenges that any developing country, mostly in the world, come across in terms of providing healthcare service. And public hospital, by and large, tends to be the epitome of medical negligence, not only in South Africa, but even in other developing countries, because of first and foremost, the shortage of staff. If we are to look at the shortage of staff, we have to look at such also in the context of the working conditions, like the current scenario, the current pandemic that we've been facing is just kind of a revelation as to what the public hospital tends to face in terms of ratio. For instance, a nurse can deal with about 30 to 40 or maybe 50 patients per day. And under such circumstances, the demand for the service and the attention that is to be applied, because we're still talking about human beings that still have got an ability to concentrate, and if we overwork, that also ability can be eroded. So shortage of staff is one of the factors that has been contributing to increase of medical negligence. In the sense that we are looking at the shortage of medical practitioners. They could be doctors, they could be nurses, they could be paramedics. Most of the doctors that tend to attend to public hospitals, some of them have got their practice. So at the end of the day, they have time that they need also to give or allocate to public hospitals. But the shortage is one of those factors that I can put forth. The second factor that I can refer to is shortage of qualified medical practitioners. Unqualified medical practitioners tend to be given tasks which they may not be able to handle. And such also contribute to medical negligence because they end up doing that which they're not supposed to do for the lack of knowledge and for the lack of skill. And also one of the common things that is a contributing factor is the working hours and the workload, which tend to also be related to the shortage of staff. Working hours is, I think they will understand that the mental workload can interfere with one's ability to process other stimuli. So for instance, one can refer to fatigue. Fatigue, if one is tired, you can't avoid it, and you can't also avoid the diminished concentration. But here in this sector, we are dealing with life and death situation. Given such a nurse or given such a doctor, given fatigue, given diminished concentration because of working hours, they may end up not providing the best quality of service to any patient that may be exposed to such a doctor or medical practitioner at the time. So that's one also a key factor that to take into account. And the other factor now is linked to outside the medical sphere, in the sense that the legal field, the attorneys, are now relying more on contingency litigation, in the sense that it's contingent-driven litigation. Most of the medical cases are due to contingent base, in the sense that the lawyer will carry the cost. They can fight for the patient who becomes or who will be their client going forth in terms of litigation. So because of that, a backlog is also created because more cases are now resulting because attorneys are taking such cases based on no win, no fee basis, in the sense that they will only charge their fee if they are to win the cases at the end of the case. So that's another factor that also needs to be considered. The other factor that also needs to be considered is the shortage of facilities. If we are to look at rural public hospitals, they may not have competitive facilities in comparison with urban public hospitals. So the disparity does cause a shortage in, contribute to the increase in medical negligence in South Africa. The other factor that I may want to dwell upon is that of the increase in public awareness regarding their rights. It goes without saying that the more people are aware of their rights, for instance, notwithstanding that there could be an exemption if you go to hospitals, we are not liable, that's what the hospital will say. If we are to, then you sign that exemption form. But still, you are informed that you can still contest, you can still take them on, based on Consumer Protection Act. So at the end of the day, the awareness of people's rights also contribute to that. Mm-hmm. Last but not least, we also need to consider legal aid role and the health insurance that is also involved with a knock effect.
Council, can I ask a question there before we go further? So, I mean, if we look at this from a human rights perspective, if we look at it says that everyone has a right to respect his or her human rights. Everyone has a right to self-determination. Everyone has a right to physical and mental integrity, as well as the right to privacy. So if we put medical negligence into perspective and trying to express it from a human rights basis, how can we try to potentially decrease the effects of medical negligence? Because you have said that it's on the rise at the moment. And one of the reasons is because of the shortage of doctors. So could telemedicine or anything like that actually play a role at the moment in terms of trying to reduce workload of doctors so that they're working effectively to reduce medical negligence?
The last question is how do we decrease medical negligence increase? It's like the current increase. How do we kind of address it?
Yes.
Oh, okay. No, it's fine. Thanks for that question. I think the ball game resonates around public policy. If the government is keen, because statistically evidence is there that there is a problem. We can't look at the rights, because it's like every right in the Constitution ought to be weighed with other rights. So if we are to look at in the Constitution also socio-economic rights, the right to healthcare is also provided in the Constitution. But the government is not doing enough in terms of addressing some of these issues. Because if I am to look, if I am to look at the common claims in South Africa, what are the factors? What is it that is contributing to such like burst operation, like faulty blood transfusions, treatment of treatment delays? These are some of the examples. If you had to look at it, it boils down to, for instance, how is the government managing the medical practitioners? Are the nurses motivated to work? Are the medical practitioners paid adequately? Do they have the tools to do the work? Because if they don't have the tools to do the work, certainly the quality and the end product is still going to be in the negative. So the only way to address such issues is by looking at what is it that is causing, for instance, the increase. In this case, look at the shortage of staff. How can we arrest by at least increasing the number of staff, recruit more, train more nurses? If it is medical practitioners, train more medical doctors. So at least the demand with the patient can be balanced. If I am to refer you to the current pandemic, the demand for service was overwhelming. If we are to look at in comparison with the medical practitioners, the medical staff. So it's one of those key elements under normal circumstances whereby now you have to deal with a shortage of staff and who are now working under unfavorable working conditions. Such, at least if there is a progressive approach from the government, I think that can be in the positive direction. And also, it's like the shortage is also linked to the shortage of staff is also linked with the shortage of facilities. Because even if you have got the manpower, but if they don't have the tools, they can't deliver quality work. And the working hours, the workload. And that's another key factor. The other issue I wanted to just highlight before I forget is when the medical students are done, let me give an example, those students that are studying medicine, they also need to be made aware of such key issues. For instance, what is medical negligence? The knowledge around it. If it is to do a course in medical negligence before they are sent into the industry, at least that information can empower them in terms of, okay, if I do this, this may end up being the result. They may liability, and this may be the case. Someone may claim. So that some of the information can be actually be part of the issue whereby it's a syllabus issue from varsity level. Some can be coming from the government in terms of policy. When the parliament says, okay, fine, these are the challenges, but what are they doing about such issues? That becomes, I think, a perennial issue every year in, year out, because the increase is not stopping, just increase, but which means there is no arrest of the problem. by those in power.
Thank you, Counsel. A follow-up question for me then would be with regards to the increase in numbers with medical negligence. How exactly is the contingency fee that an attorney is taking kind of contributing to that increased rate?
It's one of the factors. Not the main factor. It's like most of the attorneys are litigating in medical negligence cases. But when they look at the reality of their clients, or the patients, they may not have the ability to pay because litigation is quite expensive. On an average, you are looking at a period between 1 year to about 6 years fighting. If you are lucky, then basically, which means it can be resolved within a year, depending with the evidence gathering and everything because of the red tape involved. So the contingent-driven litigation is also contributed, but it's not the only factor or a dominant factor. It's one of the contributory factors because if you had to say, let's remove the contingent aspect, you will see very few people approaching lawyers for assistance because it's about the ability to finance the litigation from the beginning to the end. So now the lawyers are carrying the burden or the legal cost for such cases. So it's like if you had to look at the litigation, then you are looking at the other aspect whereby some would want to use ADR as a way of resolving dispute because you can't carry the cost for about 6 years, financing a cost whereby you can find a solution in settlement. So most of the dispute may end up being settled. But most of the cases, I think by nature, lawyers would want to fight cases. The longer it's prolonged, the longer also they make money out of it, and depending on what they are claiming and the merits of the case also. So I think that is one aspect that is contributory, but it's not the main factor. It's a contributory factor to an increase on a national scale.
And then, Counsel, could you please touch on the litigation process? If someone was interested in doing a claim, a medical negligence claim, how do they proceed? What are the steps that they need to take?
I think litigation by its nature is more of saying it's a fighting kind of approach to resolving any conflict. The most ideal way is to approach legal experts because you need to know what evidence to gather. You need to know whether your case has got merits or it does not have merits, because sometimes you pursue a case which is not meritable because it's about time, and you end up wasting time by in pursuit of something that is not tangible. So most of the issues will be, for instance, they need to approach a legal expert, and then they issue summons. Summons is a way of starting the litigation process. So in issuing summon, it's still based on two critical factors. There ought to be evidence that there was a breach of the duty of care, because earlier on I chat that doctors have got a duty of care. They need to exercise with skill and to have care. If there is a breach of that element, then basically evidence ought to be gathered that there was a breach, in the sense that the conduct of the medical practitioner did not fit into the fit and proper or reasonable legal practitioner expected in the society. Then after that, they also need to gather evidence regarding causation, that if it was not for this conduct, then this could not have happened. The injury could not have happened, the damage could not have happened if it was not for the commission or the omission of the doctor in conducting the either the operation or in attending to the patient. So once the summons have been drafted, they should include all these factors. In this scenario, the burden of proof rests with the patient, who becomes the plaintiff. So at the end of the day, evidence is critical. Just like in any litigation, without evidence, then basically it's difficult to win any case. So it's about medical reports. When you say it's like, I was in hospital, there was a botched operation. So one will still need to request for, there are forms that one has to complete for requesting for forms, for requesting for medical reports is a medical certificate from the hospital upon which that person was admitted to or was attended to. So evidence is critical. So in terms of someone's need to capture that, and someone's are based on evidence, and the burden of proof still need to be shown based on balance of probability. But the patient will still need to have that burden.
Thank you, Councillor. Ms. Khawapi, is there anything that you would like to ask or any burning questions? I know you are in the medical field.
Yes, thank you so much for such an informative platform. I've learned so much. I wanted to ask Advocate Chamisa, how successful have medical negligence cases been from the public facilities, mostly because I get the understanding that our institutions always try to protect, our health professionals, and it's very seldom where we actually hear of convicted health professionals in the field. So I'd like to know just how successful have these cases been from the litigation process?
Okay, thanks for that question. Mostly it's like when one is pursuing a case, it's mostly likely that the public hospitals is mostly likely because the employees that work for public hospitals, they report to the hospitals. It's not their hospital. So mostly in such situations, the public hospital may not want maybe to disclose, but there are many cases whereby I think statistically, if you want such information, I can provide to you, whereby hospitals were taken on. And if you are to look at the budget for public hospital that is allocated every year, bulk of it goes to compensation to these medical negligence cases. So because bulk of it is competing with the budget that is needed for other competitive services, it ends up being also used for compensation. So I think most of the cases, because even the increase is indicative that there are cases that are successful. Certainly people can't rush to when there is no success in litigation regarding such. Most of the issue that may not be into domain of employees would be the concept of vicarious liability. A medical practitioner may not be sued directly, but the hospital will be sued because you are looking at the ability, who has got the ability to pay at the end of the day. So the doctor may say, okay, I was working, but if the millions that you are claiming, I don't have it, I'm not going to be able to pay it. So naturally, you're going to be able to cite the doctor because the doctor still need to give his or her version, or any medical practitioner or the nurse, what happened if there was maybe a child injury or child death during the giving of birth. So at the end of the day, those are the factors that we want to solve. But the other side, the first defendant would be the public hospital for whatever name it's going to be. Then maybe the second defendant will be the doctor that was involved. But at the end of the day, you are not claiming against the doctor. You are claiming against the public hospitals because they have the means to meet your demands. Because if you have to claim millions, certainly you can't expect that to get it from a medical practitioner.
Absolutely.
So I think the success in claim is there statistically. It may not be within the domain of the employees. That's why I was saying before the medical practitioners are sent into the field, it is just necessary for them at least to be exposed to such, even as a course or what, but workshop. But it's quite necessary for them to have that at the back of their minds when they are in the industry, so that at least they'll be well equipped and knowledgeable regarding such. I hope I've answered your question.
You have answered my question. Thank you very much. And I actually agree with the point that you raised in terms of medical negligence maybe being incorporated into the syllabus, because a whole lot of health professionals go into the field and we see patients and you hardly ever know of, like some of the points that you've raised, like you can actually be summoned for maybe delaying in time in treatment or not giving the gold standard treatment to patients. So we're unaware of some of those factors that could ultimately lead you into a medical negligence case. So it would have been really, really beneficial for health professionals to know this information. So I agree with that, but I wonder which way would it then become a reality? Like, why are universities not considering that, seeing that there is a rise and increase in cases? Oh my God, we have less than a minute, so I'll stop it there.
I think technically it can allow you to proceed, if I'm not mistaken. I don't know, but I doubt if that will cut you off.
Now, thank you so much, Ms. Khaupi, for those inputs. I completely agree with you that medical negligence needs to definitely be within the syllabus so that medical practitioners are a bit more aware of what the processes are. So just to summarize a bit of the conversation for this evening, thank you, Mr. Advocate Denise, actually, for providing us with basic definitions of the litigation process, as well as the factors that have actually increased claims in medical negligence and the common claims that we are seeing currently with regards to medical negligence. So thank you for making us aware in that regard. And I'd like to then actually just thank the audience for participating and to leave you with a small quote. Ignorance allied with power is the most ferocious enemy of justice. Thank you everyone for being here tonight. Our advocate will be with us again in the next 2 weeks to follow up on this medical negligence series. Thank you everyone. Have a wonderful evening.
Thank you for the time. I appreciate it.
Thank you so much. See you next time.